Dear viewers, when we started our NRI Money Clinic a year before, we had promised to you that we'll bring subject matter specialists from different fields to talk to you. Due to COVID, we could not act on this. Till now, we have covered various topics, the stock markets, investments in mutual funds, financial planning and several topics. We haven't touched on the real estate sector. Today, we are talking about real estate sector in this particular episode. To talk to you on this subject, I have brought here a very distinguished faculty member, Mr. D.B. Mehta. He will be talking to you on the RERA, Real Estate and Regulatory Act in India in this episode. I am Dr. Chandrakant Bhatt here, investment consultant and financial planner.
NRI Money Clinic. No hype, just the right advice.
Dear viewers, it gives me immense pleasure to introduce Mr. D.B. Mehta to you all. By qualification, he is a chartered accountant. He is cost and management accountant. He is a bachelor in law. Mr. D.B. Mehta comes with enormous experience in various fields. He started his career as a chartered accountant, then became a government servant as an IRS deputy commissioner, and he resigned long back to pursue his other interests. He has interests in business, he has interests in financial markets. He has business interests in renewable energy, Karnataka as well as in Maharashtra. He has real estate interests in Mangalore and Bangalore. He is chairman of a business venture called Allegro Builders in Mangalore. Apart from this, he has served on several committees advising the district commissioner, the state governments, and several other stock exchanges. For nearly 5 years, he has been the president of Mangalore Stock Exchange. He was the director of Interconnected Stock Exchanges of India. Currently, he is the independent director on Smart City project of City of Mangalore. Welcome to this show, Mr. D.B. Mehta, sir.
Thank you so much. Thank you.
In today's episode, we are going to talk about this RERA. We have heard that the enactment of this RERA law has changed the landscape of real estate in India. Can you just tell us what is this RERA law all about?
See, as we all know, real estate sector prior to RERA coming into force was an unorganized sector, and there was a need felt both by the trade and the apartment purchasers that there should be some control and regulation on the construction industry. So the government brought in Real Estate Regulation and Development Act, which became a law in the year 2017. Now, as you know, the name of the act, it's a real estate regulation and development, special emphasis on regulation and development. So the law promotes both aspects. One is to regulate the trade as well as to promote the development of the real estate sector.
Okay. Now, when we talk about RERA, is it an organization? Is it a just a act, or how does it get implemented? What's its organizational structure?
See, the Real Estate Regulation and Development Act, called in short RERA, was enacted by the Parliament. Each state was asked to pass the rules to implement the RERA Act, and each state has established a regulatory authority. Now, this regulatory authority is headed by a 3 members committee, chairman being the senior most amongst the 3, and with 2 committee members with bureaucrats from the state government. So, it's a regular administrative body now.
Okay. Now, you have been in this real estate for such a long. Do you think real estate gets a boost because of this RERA law? How does it, the real estate gets a boost because of this particular law?
See, 2 things come out with the RERA. One is to boost the confidence of the end users, the end customers. That was lacking because a lot of fly-by-night operators were functioning in the real estate sector, and a lot of people who invested their hard-earned money ended up either losing it or never getting the apartments from the developers. So, A, it was to protect and benefit the customers. B, it was to weed out these fly-by-night operators. The Real Estate Act has been so designed and implemented that it is impossible for any fly-by-night operator to exist under the RERA.
So it has become a safety feature for the investors in this particular
It's an
thing.
absolute safety net for all the home buyers, and not only a safety net for the home buyers, it promotes organized development. It brings in confidence in the customers, which leads to growth in the market. So it's a beneficial act to both the developers as well as the customers.
Okay. Can you just run through what are the salient features of this RERA law and what are the things that in a very simple way an investor can understand, the salient features of this RERA law?
So, like government has come out with regulators in different sectors, be it stock market, which is SEBI, or insurance, we have a regulator there, telecom, we have TRI. So, similarly for real estate industry, RERA is the regulator available in each and every state today. Now, the basic concept of it is interface between the end user and the purchaser through an organized government system, where what the developer is doing is known both to the government and to the customer, and what a customer is behaving and how he is behaving is also getting captured through the RERA, and it helps in getting statistics, it helps in protecting customers' interest, it helps in developing the whole industry as such.
Okay.
Yeah. Now, looking at the salient features, no developer can promote any project which is more than 500 square meters in land area or more than 8 units in residential or commercial without getting himself registered with the real estate regulator. So, the minute a developer gets himself registered, means the customer has that confidence that herein the regulator will protect his interest.
Okay.
So, that is the starting point of the law. The second main feature of the law is protection of the customer's interest in terms of delivery of the product which he is buying, in terms of the quality specifications, amenities of the product which he is buying, in terms of the security of his payment which he is making to the developer. As well, the developer is also secured, because if the end user does not pay, then what are the options available to the developer?
Okay.
So, even the developer's interest gets secured in that.
Okay.
And in case if there is a dispute between the end user and the developer, RERA provides a mechanism of resolving this dispute through quasi judicial functions. Then if the customer or the developer are not happy with the order of the RERA, there is an appellate tribunal mechanism available where an appeal can be filed and the issue can be redressed. There is even a consumer redressal mechanism available. So, if both the developer and the consumer do not want to go for litigation in a quasi judicial manner and want to settle the issue through redressal, even that mechanism is available under RERA.
So, mutual consent kind of.
Through mutual consent also the issues can be resolved.
Okay. So, you mean to say that with the enactment of this RERA law and its practice, the investments in real estate sector has become foolproof for the investors, or are there still the loopholes in this?
I would put it in this way. Earlier, prior to RERA, there was no guarantee to your investment. There was no guarantee to the time of delivery or the specification and amenities which you are buying would get delivered to you. All those things are virtually guaranteed under RERA.
Okay.
There are certain small issues, but any new law, any new regulator, when it comes in a country as large and diversified as ours, we will have teething problems. So, over a period of time, all these teething problems should get evened out. Otherwise, according to me, it's a 100% safety net which has been provided under this act to the end users, to the consumers.
Okay. There are many NRIs who have purchased real estate in India in the past years before this RERA has come into existence. and many of the builders have not delivered the flats or whatever the promises that they have made. These are prior to RERA law. So what happens to such projects or such investments which are made earlier with respect to this RERA law?
See, RERA came into effect in Karnataka in July 2017. The act has come into effect in different states at different point in time because they were supposed to enact their own rules and give an effective date of implementing the act.
Okay.
So let's talk about Karnataka specifically. It came into effect from July 2017. All the projects which have not received completion certificate as on the date of the effective implementation of the act in July 2017 also have to get registered under RERA.
Oh, even the unfinished ones?
All the unfinished ones, whether they are under construction, under progress, or they have been stalled, or no progress has happened for a few years, or license was taken 2 years back or 5 years back or 7 years back, irrespective of the time frame, if the project was not completed, an occupation certificate was not received as on the date of implementation of the act, which is July 2017, all those promoters compulsorily had to get registered under RERA, and all the buyers who had booked apartments in those buildings get full protection under RERA.
Okay. Now we have this law and everything has been put in place. In spite of this, if things go wrong, let's say that the builder he's a individual and he passes away and something goes wrong and the financial problems come in. So if an investor has grievance in any of these things, how does the redressal happen here?
See, everything has been taken care of. Now, say suppose the project does not move forward because of the reasons mentioned by you, the death of the promoter or financial bankruptcy or insolvency of the promoter, then there is a mechanism under the RERA Act where if a person who has booked the apartment, he files an application with the regulator can hand over the entire project to a consenting developer or promoter who wants to come and take over the project.
Okay.
Or if nobody is available, even to a government entity, like in case of Amrapali in Delhi, where it has been given to NBCC. NBCC is a government enterprise to complete those Amrapali projects in Delhi. And these projects in Delhi run into thousands of apartments and hundreds of buildings. And those have been handed over to NBCC to complete and hand over to the customers. So a mechanism is worked out where the new promoter gives a proposal that what are the funds required by him to complete the project, what are the funds he can recover from selling the unsold flats or the balance amount recovery from the customers. So on one side total expenditure, on other side total inflows or revenue from the project, and if there is a deficit, he is allowed to bridge that deficit by collecting that difference from the existing customers. So that the project becomes viable for the new promoter. And in that scheme, now NBCC has started the development of Amrapali's taken over project under RERA, and they will be soon delivering building after building. So that issue is also taken care of under RERA.
Okay. Prior to this RERA, we had builders announcing the projects, then they were going on collecting the money. The money which is collected from the investors, nobody knew where this money was going to be utilized. The news is that the builders used to use it to complete the previous projects and they will wait for the new money to come in to take off this project. All these things, how it is controlled under RERA, how does an investor is very sure that the money that he has put in for this particular project is used only for this particular project? The utilization part, how does RERA ensure that it goes only to that project? Otherwise, if the developer uses it for something else, then we are back to square one.
So now there are two aspects which you have raised in this question. One is whether any pre-launch or pre-booking can be done after the RERA coming into force. The answer is simply no. Any developer without getting a RERA registration number and RERA will give the registration number after he gets all the permissions, NOCs, license and everything, whatever is required under the law to start the project. Only after obtaining all those permissions and clearances, he will be given a registration under RERA.
Okay.
Till the time the registration number is not issued, builder cannot market, cannot advertise, cannot promote, cannot collect any advance, cannot sell any flats or plots in advance till the time RERA number is issued. So, no pre-bookings, no pre-launches, it is a closed chapter. If any builder does that, and if any individual, even a citizen of this state, if he complains that so and so developer is launching the project and he does not have a RERA registration, under the Act, RERA has an authority to issue a show cause notice to the developer and impose very heavy fines.
Okay.
The fines imposed runs into lakhs and sometimes even crosses a crore, depending on the gravity of the offence.
Okay.
So, that issue is taken care under RERA. What a end user or a real estate purchaser has to look at is, before giving even 1 rupee advance for any project or any layout development, he has to see whether the developer has a RERA registration number.
Okay.
When he gets the RERA registration number from the developer, he can go to the RERA website and he can check whether that project is actually registered or not.
So, having a RERA registration itself is a guarantee that the due diligence has already been taken place, has been taken care of, and the investor, even if somebody gives this is the RERA registration number, he need not take it on its face value. You can go to the website of the RERA, the organization, and you can check whether it is real or not.
Not only he can check, to get the registration number, the promoter has to upload all the documents, his title paper of the property, the legal clearances obtained, the NOCs, permissions and licenses obtained, and the finances he has, his past balance sheet, profit and loss, everything has to be uploaded on RERA, and which is for public viewing.
So, which means legal opinion becomes easier now with RERA.
Everything is available under the website. The only thing is, the person who is investing should spend at least 1 or 2 hours to study all these documents,
Okay.
and then take an informed decision. Now, after having known that the project is registered, the worry will be, if I give builder money, whether he will use it for the very same project or he will divert the money out of the project. Now, that has also been taken care of under RERA. Every promoter has to open an escrow account project wise. He cannot operate only one current account and run multiple projects.
So, it's a designated account
It's a
for that project
designated
itself.
bank account for that project only.
Okay.
And he has to upload quarterly all the details of apartments booked or plots booked, how much money he has collected from each person he has sold the apartment on a quarterly basis, and whatever money he collects, only 30% he can withdraw for his other expenses and other investments, but 70% of the money he has to use to complete that project.
Okay.
He can only use that money for the construction activities, not for marketing, not for administration, not for diverting and buying other land.
Okay.
And quarterly reports have to be updated.
Okay.
And these reports are certified by 3 agencies. The financial aspect is certified by the chartered accountant. The progress of the project in terms of execution is certified by the civil engineer, and the architect also has to certify based on the size of the project, the design of the projects and everything else.
Mr. Mehta, before this RERA law came into existence, there was one another problem the investors were facing. There was no standardization. For example, the flats were sold as on super built area or on the carpet area. These are the various terminologies which are being used, and many of the builders is said that they used to have large balconies. They used to charge it for the whole property based on that easy to construct spaces there. There was the issue of deviations. See, for example, there were no parking spaces. Are there any standardization measures, or are there any set pattern for each building? How much of parking space should be given? How much of setbacks have to be given? All these things. Can you give a brief description of how these things are handled in the RERA law?
See, your question basically deals with two issues. Issue number one is, what is the unit in which the apartment can be sold? And the second question is, what happens if the builder violates the existing master plan or the zoning regulations? Under the RERA, we can even today charge the customer based on the calculation of super built-up area. That is not been prohibited.
Okay.
But what RERA mandated the promoter to do is to give the purchaser the exact carpet area of the apartment and the balcony area separately.
Oh, they have to describe it.
They have to give this carpet area of the apartment is X square feet, and the carpet area of the balcony is Y square feet.
Okay.
And these areas have to be reflected in both agreement for sale and the sale deed.
Okay.
In the agreement for sale and sale deed, you cannot sell the super built up area, but the charging mechanism is left to the builder and the consumer, how they decide the pricing. So whether you calculate it on carpet area basis or super built up area basis, that's not relevant. What is relevant here is the customer is aware that this is the carpet area of the flat he is buying and this is the carpet area of the balcony he is buying.
Okay.
And the second aspect of your question was with regards to violation.
Yeah.
Now, the question of builder violating simply does not arise under RERA. Because under RERA, he is mandated to get the occupation certificate from the concerned city corporation office. If he does not get the occupation certificate, the rights given to the people who have booked the apartments are enormous. The first right they have is they can cancel the apartment and ask the developer to return the entire amount which he has given with interest.
Okay.
With interest from the day the money has been paid.
Okay.
And this interest is nothing but 1 year MCLR plus 2%. So take the MCLR as of today is 7%. So he will be paid at the rate of 9%. Now no builder would want to take that risk where all the flats which he has booked get cancelled and he has to refund the entire amount back, including principal and interest, which will bankrupt him.
Okay.
So the risk involved and the cost is so punitive that no developer now onwards will dare to sell an apartment with violations where he fails to get occupation certificate. So RERA registration ensures that to the end user.
So all in all, it is fair to say that the enactment of this RERA law is a changing phase of real estate or the organized development of real estate in India. Thank you, Mr. Mehta, to bring all these points for the benefit of our viewers. We would like to hear your views on several other videos in days and weeks ahead. Thank you very much for coming on our show on behalf of all our viewers.
Thank you.
Dear viewers, hope the topic that we discussed today was of use to you. If you like the topic that we discussed today, please give me a thumbs up. If you are watching this program for the first time, or if you are yet to subscribe for this channel, please hit the subscribe button and press the bell icon. Thank you very much for watching this episode on NRI Money Clinic. We will be back with you with one more episode very, very soon.
Press the bell icon for more details and subscribe our channel.